Recently, following what transpired during the court proceedings when Nnamdi Kanu appeared in court this and last time, a lot of people have been asking questions to know the reason why Nnamdi Kanu always stands up in the courtroom to defend himself. So some people are saying it is it the incompetence of his legal team and so on and so forth. I found this piece to be very interesting. And Lord Ejimakor, who is the lead counsel to Nnamdi Kanu, explains everything that led to Nnamdi Kanu standing up for himself in court. I think this will be very interesting to you. Take a listen.
Okay. Thank you very much, sir. It's always my pleasure to have you around, and thank you for honoring our invitation whenever we reach out to you. For the benefit of a lot of people who don't understand the role you're playing in Mazen Nnamdi Kanu's case, could you please tell us what is your designation in that case?
Well, first of all, I met Mazen Nnamdi Kanu initially in 2017, and he gave me some special briefs to handle for him and for the IPOB, and I succeeded in virtually all those briefs. But sometime recently, he also handed over the brief of his case, the case that lies before Justice Binta Moritella Nyako, the main case. I like to call it the main case, which is the mother of all cases, all the cases that concern Mazen Nnamdi Kanu and the IPOB sprang up from that one, or are subordinate to that. So he also gave me that one, and my instruction is to lead the defense team in this case, and that's what I've been doing. But I'm not a person given to titles, so I'm really not too excited about use of titles. I'm too excited about getting some results. That's my thing. Thank you.
Okay, so the reason why it's not really because I am thinking that you are, extra excited about titles. I know who you are, but just to be able to put things in the right perspective and people to know the position you occupy in the Mazen Nnamdi Kanu case. But yeah, just like you have said, you are the lead counsel, you are the lead of all the teams in the case. I assume I'll be right to say that, sir.
Yes, I'm leading the defense right now in this very case that happened yesterday. I think it's very obvious that I'm leading the defense team.
Okay, sir. Now, bring us up to speed with Mazen Nnamdi Kanu's case, and in doing that, help us understand exactly what happened yesterday. We saw a lot of videos, we saw a lot of animations, a lot of sparks here and there, and people are having their own interpretation of what happened. But as somebody who is there, help us to understand where the case is at right now. And
yes, anyway, like you said, a lot of videos were recirculated in the social media yesterday. Some of those videos speak for themselves, but I have seen some twists and some tons of interpretations and misinterpretations of what some of those videos represent. But whatever it may be, what happened yesterday in court was quite embarrassing to the Nigerian judiciary. Not to us, but to the Nigerian judiciary. Even lay people are aware that once an order of court is entered, the only way you can override that order is to appeal and get it to be set aside. There are some other circumstances where you can have the same judge who entered the order to set it aside, but that is too far and in between. The two situations that might arise and qualify will be if the order was obtained through fraud, misrepresentation, or the judge had issued the order without authority, without jurisdiction. But none of those factors were present, but we got invited. We got someone to appear in court, and when you get summons from a court, whether you believe the court has jurisdiction or whether you believe he did anything wrong, he had to appear. That is in the best traditions of the common law system. So there was no way we could thump our nose at the court, even though we had the full assurances and confidence that the summons was flawed at law. The judge, the same judge who was recused, had no authority to summon us. So we went to court yesterday to tell the judge exactly that, and also to ensure that we are present to protect the constitutional rights of Mazi Nnamdi Kanu. If we were not present, our absence could be injurious to his constitutional and legal rights. So we had to be there to make that point that to the judge that hey, listen, you don't have anymore, you don't have any business with this case anymore, and that's it. But that thing, it didn't seem to be sinking in, and I believe I have to bring you up to speed how it started, because how the cookie crumbled. It was the prosecutor, the private prosecutor for the federal government, who began to speak first, informing the judge that the prosecution is ready for trial. Are you listening? Are you hearing me?
Yes, we're hearing you, sir. We're hearing you.
Okay. So that's when I got up. And raised an objection on the record that the court had to inform us first while we were there. So the court began to inform us with a lot of aplomb and authority, purporting to be to still possess jurisdiction. I opposed that vehemently, and it went on back and forth between me and the prosecutor on one hand, and between me and the court on the other. And Chidi, as you know, in every common law system, even where you live in Canada, a defendant has the right, or let me say the privilege, to address the court if the court so permits. So those people who want to say that Mazi Nnamdi Kanu was rascally, those people, they are not, I don't know whether it's a product of propaganda, but he just didn't get up and disrespected the court and started speaking. He was permitted to speak from the dock. That is how lawyers put it. He asked for permission to speak, and he has the right to speak. Well, you can say a privilege. In some situations, it could be a right. But in this situation, let us just assume it's a privilege. So the judge extended that privilege of speaking for himself to him. And the way he spoke is the way every defendant presumably would speak. They speak from the heart. No, you would not expect him to speak like a lawyer who is robed and with his wig and gown and everything. We have some boundaries of privilege when we speak in court. There are lines we can't cross ethically and professionally. But a defendant is permitted to speak from the heart. That is the purpose of it. You speak from the heart, you tell it the way it is. So that's exactly what he did. But some people may have mixed feelings about it. But, he let the cat out of the bag, and that's it. And you can say that his lawyers were the carrot, he was the stick. So, be that as it may, the purpose was achieved. And the purpose was that ultimately we did not submit or succumb to the authority of the court to recalendar the case and try it, having been recused pursuant to an extant court order. So whatever the court did at the end is a nullity. The court purportedly adjourned sine die, meaning indefinitely. If you don't have authority to hear a case, you have no authority to enter any subsidiary order, such as adjournment, CDI. So we have a whole lot of options we can pursue, rising from yesterday, but I'd rather keep that very close to my chest. I don't want our legal strategies going forward to be for public consumption. Thank you.
Thank you very much, sir. That's really why we wanted to have you here. Now, a lot of the things that you'll be saying here will be easier for people in the wig and gown of your profession to understand. But to lay people like me, there are some questions that I'm going to ask you, which will represent a lot of what has been flying, up and down online. One of them is this. Even though you've talked about it, but I want to ask you a straight question. You had asked that the judge recuse herself from this matter, and you have said that the judge does not have jurisdiction over this matter anymore. My question is, why did you still go to court, knowing that this person sitting there is someone whom you have already said does not have jurisdiction over
Okay. Let me just take this question very quickly. I mean, anybody listening here is living in one country or the other. Every nation is organized under a set of laws and a constitution, and law and order must be in play. I mean, there's no country in the world where you live and at the same time you disregard the rules and laws and processes of that country. We have no authority within the confines of the territorial boundaries of Nigeria to thump our nose at the judiciary and say we're not going to court. Who are we? Come on. People need to get reasonable. Marcel Nnamdi Kanu is in detention and people expect him to say, I won't go to court. He could possibly be taken to court forcibly, and it will be very embarrassing. And if we as lawyers say we won't go to court, it might even be tantamount to professional malpractice. That we fail to go to court. We went to court on a limited appearance. I announced it in open court that we're here on a limited appearance and we're appearing under protest. It is done, even in Canada where you live, Chidi, and everywhere in the world. It don't say you won't go to court. Even police summons, common police summons, you must answer. And you go there and protest your innocence, but you won't say, I won't go to court, I won't go to police station because you believe that they have no authority to summon you. You just can't do that in any country. I don't know why, in the case of Marcel Nnamdi Kanu, some people expect different or expect the lawyers to act differently. As if the lawyers are some thing gods. We don't have the coercive powers of the Federal Republic of Nigeria, which we do. In that case, we shall now, marshal or purvey those coercive powers to prevent some injustice from being done. But we live under the authority of the state, pure and simple. It's a hard truth, very inconvenient truth, but it is the truth. So if the court says you must come, you go. You don't stay in your house and decide that the court doesn't have jurisdiction, because the court can proceed in absentia. It can proceed with the proceedings in your absence and enter some orders or rulings that will be permanently injurious to your legal interests. And then how do you defend that? Reasonable men and women, even non-lawyers alike, will be asking you, but what authority do you have to refuse to honor a court order? It's a court that summons a man, he goes to court and proves his innocence, and he's sent home and he's set free. So you don't stay in your house, or especially for someone who is, within the confines of a security agency detention facility, and you say, I won't go to court. Something got to give. So I don't know why this is hard for people to understand. But Chidi, quite frankly, I think a lot of people understand it, but it's a mischief. There's a certain mischief that is coming from people that are fronting to be Igbos or to be our people. I don't know whether they are fake or real, but they engage in this continuous mischief or finding fault every time in somebody and trying to lay blames that shouldn't be laid and so on and so forth. And from there they now begin to engage in whole scale acts of blackmail on the social media. But the legal team is not perturbed. We have a job to do, and that is that's what we are concentrating on.
All right, thank you very much, sir. The next question is this: when you requested for the judge to recluse herself, I've heard in some quarters that that request was not granted, and that was why the judge was back in court. So could you speak to that? What happened after you requested for her to recluse herself from the matter?
Okay. Well, after this segment, I will ask everybody to go to my Twitter handle. It's a very good question. I didn't know that there is that lacuna there. I didn't know that people didn't have a full understanding of what transpired. On 24th September last year, the request for recusal was made, and the judge very willingly and freely consented to the recusal, and she proceeded to enter and enroll an order thereof. That order is subsisting and valid, and I have a copy of the certified version of it. I have it electronically, so I'm going to scroll and get the order, screenshot it, and post it on my Twitter handle. Because I noticed that people are probably not aware, they have not seen the order itself. So the recusal was a completed judicial event, and nothing was left, and that wasn't the issue yesterday. The judge had no misgivings about whether there was a recusal order or not. Rather, she was telling us that the chief judge issued a memo or some kind of a directive to her to continue with the case. So my argument, which is sound in law, is that the directive of the chief judge of the Federal High Court or a memo cannot override a court order. Even lay people know that a court order is different from a directive or a memo, even when the memo or directive issued from another judge. An order is an edict, is a decree by a court, and it has higher tenacity than a mere directive or a memo. So he might be the chief judge of the Federal High Court, but he's still a Federal High Court judge with a coordinate judicial rank with the Justice Binta Nyako. So they are equals before the eyes of the law, and under the Constitution they possess equal jurisdiction and authority. The chief judge is merely a primo inter pares, first among equals. So he cannot, by a directive or a memo, override a subsisting valid court order that has not been set aside. So that's the presentation I made in court yesterday to push back at this thing that I saw as a burgeoning unconstitutionality. So there was no doubt about a court order. The only issue was the memo. And we were not going to succumb to the contents of a memo that we didn't even see. Even if we saw the memo, our position would have been as rock solid as it was when we didn't see the memo. So that's it.
All right. The other question I want to ask, which is also questions that people have put to me, is this. We've heard about, we understand your team does not have confidence in the judge. Can someone just get up and say, you know what, I don't like this judge, and the judge will be changed? Or are you willing to disclose to us what are your main reasons for not wanting this judge to continue with the case?
Yes, exactly. Listen, on 29th June 2021, Marcel Nnamdi Kanu was suddenly presented in court before this same judge through the back doors. He was marched and they had a hood over his face, and he was in shackles and manacles. He was presented before this judge, and the last time the judge beheld Mazi Nnamdi Kanu was as far as April of 2017. And she knew of the record because Mazi Nnamdi Kanu had sent an affidavit from his location in Israel explaining to the judge. I drafted that affidavit and sent it to him. Then I was just merely his special counsel, handling special projects for him, legal projects. So I drafted an affidavit and sent to him in Israel. He executed that affidavit before an Israeli high court, and it was sent to Nigeria and filed before this court, explaining why he had to leave Nigeria. So the judge was cognizant, fully aware that he was abroad as a refugee, as somebody who actually left Nigeria to save his life. So this judge did not conduct the basic inquiry required of a judge to ask, how did you bring this man before me? Was he extradited or did he return voluntarily? What happened? She never made that inquiry, and there was no effort on the part of the court to put on notice the former counsel to Mazi Nnamdi Kanu that, hey, listen, we have a hearing, we have your man, we have your client coming before us, come and make his case. And this counsel's information was also of the record. Phone number, address, location, everything, names. So this hearing was conducted secretly without notice to counsel and without asking Nnamdi Kanu to explain himself, to speak to the judge. So the judge listened to the prosecution side only and proceeded to enter an order or remand of detention that is keeping Nnamdi Kanu in detention till today. That is a grave constitutional error that you cannot sweep under the carpet. I wasn't his lead counsel at the time. Perhaps if I was, I might have appealed it right away. So the matter, it wasn't appealed. Maybe it was a policy decision taken between him and his lawyers not to appeal it for one reason or the other. I don't know. But it was an appealable error. But it wasn't appealed. So but it's catalogued. It was an event in the history of his case that complicated the whole situation and injured his liberty interest and kept him in detention. So when I came in, it was one of the things that I considered a grave injustice done to him, and we were just waiting for an opportunity to palliate into his case in such a way as to protect his rights. Then the matter was before the Supreme Court, so nobody could do anything. But after 15 December 2023, when the Supreme Court decided the case and sent it back to the same High Court to try Mazi Nnamdi Kanu, that wasn't the only thing they decided. The Supreme Court also decided that his bail shouldn't have been revoked. There was a 29-page critique, very harsh words employed by the Supreme Court in 29 pages of the judgment, criticizing this same judge for revoking Mazi Nnamdi Kanu's bail. The Supreme Court called the process by which Mazi Nnamdi Kanu was brought before the judge a criminal conduct by agents of the state. And the Supreme Court said that for this judge not to listen to Mazi Nnamdi Kanu before revoking his bail and jailing him or putting him in detention for this long, smacks of partiality, that the impartiality of the judge has become suspect. We could not ignore that. But in the meantime, we decided, okay, let us test the waters. So we applied to the judge with a single exhibit, this judgment of the Supreme Court. We said, okay, my lord, the Supreme Court has given you back the case to try. That's not the only thing the Supreme Court said. The Supreme Court also said you were wrong to have revoked Mazi Kanu's bail. So restore his bail. And here is the judgment. You are aware of it. She refused. She refused to restore the bail. So how can a judge cherry pick the part of a judgment to implement and the other not to implement? This is unfair. Under Section 287 of Nigerian Constitution, she is bound as a lower court to implement the Supreme Court judgment.